Hi, my name is Jeff Pryor. I'm the Neighborhood Services Manager for the Village of Oak Park. I'm here to present to you an overview of the Residential Tenant Landlord Ordinance, otherwise known as the RTLO. So let's begin. On January 28th, 2021, the Cook County Board of Commissioners passed a new residential tenant landlord ordinance. This ordinance went into effect on June 1st, 2021. On July 19th, 2021, the Oak Park Village Board locally adopted the Cook County's RTO with several local amendments. This ordinance can be found in Chapter 12, Article 6, known as the Residential Tenant and Landlord Ordinance. So why the local adoption of the Cook County's ordinance? Well, by doing so, it provides the village with the ability to take enforcement actions locally. It does not prohibit the tenants from also exercising their rights to pursue civil action. These amendments provide clarification and references to the existing Oak Park Village Code and have no impact on any of the tenants' rights. These amendments make reference to the village's occupancy standard, the village's property maintenance code, and the village's heat provision. So what's the purpose of the RTLO? Well, the purpose is to protect and promote the public safety and welfare of its residents. It's also to establish the rights and obligations of the tenant and the landlord in the rental of dwelling units, and to encourage the tenant and landlord to maintain and improve the quality of housing. Who's covered by the RTLO? Almost all rental units within the Village of Oak Park are included, including mobile homes and subsidized units. So who's excluded? Well, owner-occupied buildings with 6 units or less are excluded. A single-family home or condominium is excluded, provided that the owner is only renting that one rental property. The owner or an immediate family member has lived in the home within the past 12 months. The owner personally manages the property, and the owner is not a corporation. There are several other exclusions from the RTLO. Single room occupancy housings that serve the most vulnerable residents, units in hotels, motels, rooming houses, unless the rent is paid on a monthly basis and the unit is occupied for more than 32 days, and school dormitory rooms, shelters, employees' quarters, non-residential rental properties, and owner-occupied co-ops. There is a requirement, though, that if you are an excluded unit, that you still have to provide to the prospective tenant that you are excluded from the RTLO before accepting any fees. The RTLO provides several prohibited lease provisions. These include waiving notices or requirements to renters to confess judgment, giving up rights to notices like an eviction notice, giving up the right to a jury trial, preventing the tenant from saying negative statements about the landlord, and requiring the tenant to give a longer amount of notice for moving than the landlord gives the tenant for not renewing the lease. Again, these are prohibited lease provisions. If a landlord deliberately uses a rental agreement containing any of the provisions known by the landlord to be prohibited, the tenant may recover actual damages or 2 months' rent, whichever is greater. Let's talk a little bit about rental agreements. Rental agreements must include the full names of all known occupants. Additionally, individual occupancy of the dwelling units shall not exceed the maximum permitted under Section 7-13-2 of the Village Code, which pertains to the 2009 IPMC, International Property Maintenance Code, Section 404.4.1, room area, and Section 404.5.1, maximum number of occupants. What are the renter's rights? Well, the renter has the right to property being maintained in compliance with the relevant local building codes. Again, section 7-13-1 and section 7-13-2 of the Village Code. Renters are also guaranteed the adequate heat provided in their units from September 15th to May 15th of each year. Daytime temperatures must be at least 65 degrees and nighttime temperature at least 65 degrees. Additional renters' rights include a home free from bed bugs. After notification, the landlord must provide pest control services within 10 days and must maintain written records of pest control measures for 3 years. Renters are also guaranteed repairs made by a landlord in a timely manner. If the landlord does not make repairs after notice of 14 days, the tenant may have rights such as repairing themselves or deducting rent or ending the lease when conditions are serious enough. Renters' rights also include essential services to heat, running water, hot water, electricity, gas, or plumbing. Failure to provide these essential services, the tenant can withhold rent, provided that they provide 24 hours notice. They can replace and deduct for these services. They can stay and sue the landlord, or they can find other housing and sue the landlord. Other remedies that the renter has for other issues include withholding rent as long as they provide written notice, and it is 14 days before the rent is due. They also can end the lease, provided that they provide written notice, and it is 14 days before they move out, or they can file a lawsuit. What are some of the responsibilities of the renter? Well, they're responsible for keeping the unit safe and using appliances and fixtures in a safe manner. They are required to dispose of their garbage. They are required not to deliberately damage or remove any property. And they are also agree to allowing reasonable access to their unit, provided that there is a 2-day notice by the landlord. Landlords may enter at reasonable times from 8 a.m. to 8 p.m. or at the tenant's request to make repairs, provide services, or to show the dwelling within 60 days of a lease ending. Renters' responsibilities also include notifying the landlord of bed bugs in writing 48 hours of seeing bed bugs. Renters must also pay security deposits if required. Regarding security deposits, landlords must maintain deposits separately from personal accounts, provide a receipt, and return security deposits within 30 days with an itemized list of deductions. The RTLO caps security deposits to 1.5 times the monthly rent and sets up penalties when security deposits are not returned. The renters are also responsible to comply with all local ordinance and agreed upon landlord rules. Unless otherwise agreed, only the use of their dwelling units can be used as dwelling units. They also agree not to abandon the property. The RTLO provides certain notices must be provided. Notice of rent must be a 5-day notice where the tenant has a right to stay. The lease violation, there's a 10-day notice. The tenant has a right to cure issues within 10 days. There's a non-renewal of lease. There's a 60-day notice that must be provided. And unit entry, there's a 2-day notice that must be provided. Let's talk about when the rent payment is late. The RTLO caps late fees at $10 for the first $1,000 of a rent. After that, late fees are 5% of the overall rent. Landlords must apply rent payments to the rent and not to other costs like utilities when they are received. Landlords must give a 5-day written notice for non-payment of rent, and there is a provision called the pay to stay. If a tenant does not pay during the 5-day notice, the landlord can file an eviction. After filing the eviction, but before judgment is passed, a tenant may pay and stay a one time by paying rent and certain additional costs that include filing fees that were incurred by the landlord. What are the landlord protection within the RTLO? Well, landlords have 2 business days for a right to cure administrative issues, such as attaching the ordinance summary, disclosing authorized entrance and owner transfer, and disclosing the name of the bank where a security deposit is held. Landlords also have a 14-day right to cure issues of material noncompliance with the rental agreement. The landlord has protections against property destruction and provides clear rules on when and how landlords may exercise their right to dispose of abandoned property without expensive storage costs. Landlords have 30 days to determine security deposit deductions, which may include damage repairs and some court costs. Landlords are given clarity within the RTLO on their obligations in the case of eviction, foreclosure, or non-renewal of lease. Landlords are allowed to enter a resident to make without notice to make emergency repairs. Landlords may give a tenant a 5-day notice if the tenant fails to pay rent and a 10-day notice for material noncompliance with the lease. So what's the difference between the Cook County's RTLO and the Oak Park RTLO? Well, there were 5 sections of the Cook County's RTLO version with applicable corresponding code found in the various sections of the Oak Park Currents Code. Some of these sections were clarified with the previously mentioned amendments. 2 sections of the Village's Code under Article 13-5, unlawful management practices, were deleted. These sections were Section 13-5-1.b, lease required, and Section 13-5-1.c, application and fees. These were replaced with sections in the new RTLO under Section 12-6-4.a, rental agreements, and Section 12-6.11.a, security deposit. The RTLO requires certain disclosures. One of those disclosures is of utility fees. The tenant has a right to know how much utilities cost. Landlords must tell a tenant who pays, and if the tenant does pay, provide the previous 12 months' cost. There is a requirement of disclosure of move-in fees if they are required. The landlord shall provide the tenant with an itemized list of the landlord's reasonable estimates of the costs that comprise the move-in fees. These move-in fees cannot include maintenance, regular maintenance, or upkeep fees. The RTLO also provides that there is a disclosure of past issues with the building. Before the tenant signs a lease, the landlord must provide written notice of past issues, including code violations from the current year, current code violations, and utility shutoffs coming soon or from a city or utility company. Failure to provide these can result in the tenant ending the lease. It must be within 30 days of the notice, and the tenant can also sue for 1 month's rent and legal notice. The RTLO provides disclosure of ownership of certain people. The landlord must give the tenant the name, address, and phone number of the owner, the building manager, or the owner's agent. The tenant can end the lease if this is not provided, as long as they give two business days notice and let the landlord fix the mistake. The tenant can also sue the landlord for $200 and legal fees. Lease renewals and non-lease renewals. Lease renewals is covered under the RTLO in that no tenant shall be required to renew a lease more than 60 days prior to the termination date. If the landlord violates this, the tenant can sue for 1 month's rent or actual damages. Non-renewal of lease. The landlord shall notify the tenant in writing at least 60 days prior to the stated termination date of the rental agreement of the landlord's intent to terminate a month-to-month tenancy or not renew an existing rental agreement. Failure to do so can result in the tenant remaining in the dwelling unit for up to 120 days. There are several requirements within the RTLO for lease attachments. There are 3. Attached to the lease must be the approved U.S. Environmental Protection Agency federal pamphlet on bed bug prevention, detection, and control. Also must be attached is the U.S. Environmental Protection Agency federal pamphlet on lead-based paint disclosure. And a copy of the RTLO summary shall be attached to each written rental agreement. This summary is provided by the village, and there is a link on the same page that you found this video to that summary. Where can tenants find help? Well, the tenants can find help at the Cook County Legal Aid for Housing in Debt at cookcountylegalaid.org. They also can find help at Legal Aid Chicago. For tenants who are experiencing issues with rent payments, they can find assistance through Housing Forward, which Oak Park has a local office. What about landlords? Where can they find help for the RTLO? Well, the Village of Oak Park Community Relations, Cassandra Hurt, or myself, Neighborhood Services, Jeff Pryor, can also help you. Additionally, we highly recommend you consult your own legal counsel attorney for interpretation of the RTLO. If you have any questions pertaining to this overview that was presented, you can contact me at 708-358-5412 or jpryor@oak-park.us. Thank you for your attention during this presentation.